We are proud that we are the only channel which discussed the issue of blind candidates in the Uttarakhand Judicial Services exam, and something really concrete has happened in favor of the applicants in the matter before the Supreme Court. That is which I am sharing with you today. और भी कई सारी अनाउंसमेंट्स है आपके लिए, कुछ अपडेट्स हैं. पहला जिसमें अपडेट ये है कि नाउ वी विल बी पुटिंग एवरी वीडियो ऑन दिस चैनल इन स्ट्रिक्टली इन इंग्लिश लैंग्वेज. अब इस चैनल पर जो भी वीडियो आएगी आगे वो सिर्फ प्योर इंग्लिश में होगी. हालांकि आपको इसके सबटाइटल आपको हिंदी में भी ऑटोमेटिकली अवेलेबल होंगे. तो जो कैंडिडेट्स, जो स्टूडेंट्स हिंदी बैच से बिलोंग करते हैं या हिंदी मीडियम के स्टूडेंट्स हैं, वो अपनी सबटाइटल हिंदी में ऑन करके हमारे किसी भी वीडियो को देख पाएंगे. ये शायद लास्ट सेशन है जिसके ऊपर हम हिंदी में आपसे बात कर रहे हैं. सो डोंट वरी अबाउट दैट. आपके इंटरेस्ट का भी ध्यान रखा हुआ है. आपको सिर्फ सबटाइटल हिंदी चूज करने हैं. That will help you. Moving forward, as I have mentioned that Supreme Court has passed an interim order in the issue of blind candidates who have approached the Supreme Court regarding the Uttarakhand Judicial Services Examination, whose pre-exam is scheduled on 31st August. Supreme Court has struck down the Uttarakhand government notification in which the government have mentioned that blind candidates will be ineligible for the competitive examination and any kind of reservation. That notification is of, remember, 2018. And what is its impact on the current Uttarakhand Judicial Services exam? I will explain everything in this session. The Supreme Court has also reserved its judgment tentatively to be announced on 2nd of September 2025. And in this interim order, Supreme Court have ensured that the exam which is scheduled on 31st August, that will go on as it is scheduled. Means on 31st August 2025, your exam is going to happen. There is no change in that. With the rider, with the condition in favor of the candidates who were excluded from the application process, the blind candidates particularly, they will be allowed to appear in the examination. Remember, and the Uttarakhand Public Service Commission and Uttarakhand government have also told the Supreme Court in principle that from every next notification there will not be this kind of blunder. As being the public organizations, the public institution, they have to ensure Supreme Court guidelines, Supreme Court judgments. So let's discuss what happened yesterday in the Supreme Court. We are discussing that. But before that, let's discuss the background of the whole scenario. Massive win for blind candidates in the Uttarakhand Judicial Services Examination. A brilliant law student who studied day and night, but they are blind, and when they appeared or when they approached the public institution for the government exam, the notification says they are excluded. No matter they are confident, they have the required knowledge, they have the required determination, they are eligible as per the law and the notification. Now, when they are filling the form of it, specifically in today's discussion, the central point is Uttarakhand Judicial Services Exam 2025. The system says, sorry, you are not even allowed to apply, not even in the person with benchmark disability quota, not even in the general category, you are completely excluded. Sounds unbelievable, right? But this was the reality in Uttarakhand under the 2018 government notification, which was saying this thing. And when this matter reached the Supreme Court, in 2025 in the matter of Sravya Sindhuri versus Uttarakhand Public Service Commission and others, specifically pertaining to the Uttarakhand Judicial Services Exam 2025. Justice J.B. Pardiwala of the Supreme Court called it just one word, absurd rule. Today we will break down this extremely important case, Sravya Sindhuri versus Uttarakhand Public Service Commission 2025 writ petition. This case is not just about one candidate, it is about the right to equality, right to education, right to livelihood, and above all, dignity of disabled persons in India. So stay tuned till the end, because in this video, we will be covering the background of the case, what the 2018 government notification and the argument before the Supreme Court in this Sravya Sindhuri case, how this judgment strengthened the disability rights in India, and why it matters for Uttarakhand judiciary aspirants and every other law student concerned. Trust me, once you understand this case, you will never forget this phrase, that is absurd rule. Let's discuss the background of the case. The petitioner Sravya Sindhuri is a law graduate with 100% visual impairment. She applied for Uttarakhand Judicial Services Civil Exam, Civil Judge Junior Division Exam 2025. But the advertisement dated 16th May 2025 and a government notification from 29th September 2018 created a huge barrier in her application process. What did the 2018 notification said? Let's discuss. Let me tell you that also. First, blind and visually impaired persons are not eligible under PWBD quota if they are 100% blind. Secondly, locomotive disability are also excluded. Thirdly, and the biggest shock, since they are excluded from the PWBD quota, they also cannot apply in the general category. So effectively, people like Sravya Sindhuri were completely shut out from the judicial appointment process. Now, here is the legal problem. What was the legal issue in this case? The Rights of Person with Disabilities Act 2016, RPWBD Act, under section 34 clearly mandates the 4% reservation in government jobs for person with benchmark disability candidates, and 1% is specifically reserved for blindness and low vision candidates. But Uttarakhand's notification of 2018 as well as current Uttarakhand Judicial Services 2025 exam notification gave person with benchmark disabilities seats only to 4 subcategories, namely leprosy cured, acid attack victims, dwarfism and muscular dystrophy. Blindness and locomotive disability were arbitrarily excluded from the entire process. This was a direct violation of the right of person with benchmark disabilities and also a violation of Article 14 equality, Article 19 1G free right to profession, and Article 21 right to life and dignity. That is why Sravya Sindhuri filed a writ petition in the Supreme Court challenging this exclusion. Let's move on to the argument before the court. The argument from the petitioner side, firstly, we will deal with. The arguments were, first, the notification is unconstitutional. Secondly, it violates Article 34 of the Right of Person with Benchmark Disabilities, Right of Person with Disabilities Act 2016 as well. Thirdly, it goes against the Supreme Court precedents like in rare recruitment of visually impaired in judicial services versus Registrar General, High Court of Madhya Pradesh, where Supreme Court have already held that blind and low vision candidates are eligible for judicial services. Denying even general category access to blind candidates means a complete exclusion from the judicial services post, which is unreasonable, discriminatory, and highly unreasonable classification as per Article 14 of the Indian Constitution. Even scribe facilities and extra time were not provided, violating the principle of regional accommodation under the International Law and Right of Person with Disabilities Act 2016. For the respondent side, let's discuss the arguments. First argument from the respondent side, that is the Uttarakhand Public Service Commission, Uttarakhand High Court and Uttarakhand government. The 2018 notification was as per state policy. That was the argument from the respondent side. Secondly, they argued about identified disability for judicial post. Thirdly, they raised the domicile issue, claiming person with benchmark disability candidate must be from the Uttarakhand state only. Remember, the petitioner in this matter, Sravya Sindhuri, have also raised the issue of domicile, that the blind candidates or the domicile category requirement should not be applicable to the person with benchmark disability or person with disability. That was the argument from the petitioner side in this case as well. On the domicile issue, the respondent, that is the Uttarakhand government, Uttarakhand Public Service Commission, Uttarakhand High Court, said that the person with benchmark disability must be from the Uttarakhand to apply or to get the suitable domicile benefit. However, during arguments, now remember, this is what I am telling you most importantly, what has happened yesterday in the court, in the Supreme Court. From the respondent side, that is both the state government, Uttarakhand state government and Uttarakhand Public Service Commission, have ultimately admitted that Supreme Court judgment in re judicial services case must be followed and that visually impaired persons are indeed eligible. Means the candidates are the blind or the low vision candidate are eligible. That was the admission by the respondent side in the Supreme Court. At this point, Justice Pardiwala asked a very sharp question to the respondents. So if she does not qualify under the person with benchmark disability or person with disabilities, she cannot apply even in the general category. Isn't it absurd? That is clearly an absurd rule. This became the defining moment of the case. Now moving to the Supreme Court observation and the interim order passed by the Supreme Court in this case. The Supreme Court bench of Justice J.B. Pardiwala and Justice K.V. Vishwanathan issued very strong observation. First, absurdity of the notification. Court said that it is irrational to exclude candidates from both person with benchmark disabilities and general category. Such exclusion defeats the purpose of equality. Secondly, court also stayed the government notification of 2018, which was the main reason of excluding the blind candidates from this entire recruitment process. The court stayed the operation of the 2018 government notification. Thirdly, directions for the exam. All such candidates must be allowed to appear in the Judicial Services Preliminary Examination, which is scheduled on 31st August 2025 under General, SC, ST or OBC categories. Means the person with benchmark disability like Sravya Sindhuri, they will now be eligible. They will be appearing in the exam which is going to be scheduled on 31st August 2025. The next guideline or the order of the interim order or part of the interim order of the Supreme Court is very, very important here. Facility of the scribe and the extra time. The Supreme Court directed Uttarakhand Public Service Commission to provide scribe facility to the applicants or such petitioners and 20-minute extra per hour of exam time. Another point of this judgment is the constitutional mandate. The court reminded the state that Article 14, 19 and 21 with right of person with benchmark disability or right of person with disabilities act guarantee equal opportunity to person with disabilities. Now, the most important part, the judgment in the case has been reserved. While reserving the final judgment, the court made it clear that from the next year onwards, such exclusions cannot continue. Means from the next year onwards, all the notification will comply to the right of person with benchmark disabilities as well as Supreme Court judgments. However, Justice Pardiwala words are worth remembering in this case. We will strike it down here and now. This absurd rule of 2018 notification. This was a powerful statement against the discrimination. So what is the outcome of this case as far as is this state? Though judgment is reserved, but the Supreme Court has passed an interim order confirming that the exam will happen as scheduled on 31st August 2025. Secondly, all such applicants who are excluded from the process, they will allowed to appear in the examination which is scheduled to be on 31st August 2025. Secondly, they will be allotted scribe facility, extra time, etc. 20 minutes for every hour extra time will be given as per the Supreme Court guideline, right of person with benchmark disability and other various directives. Now moving to the critical analysis here concerned. The positive aspect of this discussion or this case is that Supreme Court has again stood as the guardian of equality and dignity in the exams. This strengthens the India's commitment to inclusive judiciary. Thirdly, it affirms Right of Person with Disabilities Act 2016 and aligns with India's obligation under the UN Convention on Right of Person with Disabilities. Fourthly, it stops arbitrary exclusion by state governments. And what are the challenges which still remain? Implementation at the ground level. Will exam authorities really provide scribe and extra time properly to these candidates? That have to be seen. Secondly, domicile restriction. The issue of whether only Uttarakhand domicile can claim person with benchmark disability quota is still pending. Thirdly, systemic bias. Society and institutions often resist inclusion of disabled person. Before moving further, let me ask a very important question to you. Do you think judicial services should have a fixed quota for blind and locomotive disabled candidate across all state, or should state be allowed to make their own rules in that regard? Tell me in the comment section. Now moving to the impact of this judgment. The case will have far-reaching impact for the judiciary aspirants. Disabled candidate will now get a fair chance to compete. Selection, non-selection is completely a secondary issue. Whether the applicants in this case will become judges or not, that is altogether a secondary issue. First of all, what our constitution says, right to equality, and right to equality says equal level playing field, reasonable classification. Let them sit in the exam. Let them get the benefit as per their reserved quota. Only the results will decide, only their caliber will decide whether they will be judges in the Uttarakhand or not. The case will have far-reaching effect. One such impact I have already told you, that for judiciary aspirant, disabled candidate will now get a fair chance to compete. Secondly, for disability right jurisprudence, this strengthens the interpretation of Section 34, Right of Person with Disabilities Act 2016. Thirdly, for state policies, what will be the impact? Other state with restrictive rules will now have to review them also. Fourthly, the constitution part. For constitution part, it reinforces that Article 14, that is equality, cannot be violated under the excuse of technical rules. This case is a reminder that justice is not just about judgments, but about inclusion and fairness. Now let's move on to the conclusion part. But before moving ahead, let me provide a very good announcement for you. You know that we have been hearing that there is less content on this channel coming regularly. So on that thing, we have looked seriously, and I promise you every alternate day at sharp 3:45 p.m. in the evening or in the afternoon, you will have one video on every alternate day. Now let's move to the conclusion part. As far as conclusion part of today's session is concerned, to conclude, the Sravya Sindhuri case 2025 is a powerful reminder that India's judiciary stands as a shield for the vulnerable. The Supreme Court did not just say a notification, it restored hope, dignity, and equality for thousands of aspirants who were unfairly excluded. This case will be remembered alongside other disability right judgment as a turning point for inclusive legal education, judicial services recruitment, or all other public exam recruitment processes in entire India. With this, our session is complete. I am again revising all the outcome of this interim order. The exam is going to take place as per the schedule, that is 31st August 2025. All petitioners belonging to the person with benchmark disabilities or less PWD are will be allowed to appear in the exam. They will be fighting for the time being under the general SC, ST, OBC category only. And the Supreme Court has struck down the 2018 notification of the Uttarakhand government, which excludes such person from the recruitment process. The final judgment is about to come, or that is tentatively to be announced on 2nd of September 2025. That we will also discuss when the final judgment will be out. But it seems from the interim judgment that Supreme Court has given a clear message. Inequality in the recruitment process will not be tolerated. Rights of every section have to be taken care of as per the Constitution of India, as per the law, and as per the Supreme Court guidelines as well. Any administrative action, any executive action that will violate it, that will definitely is going to be struck. Another important announcement which I am making here, that we are launching our courses, new fresh courses for Judiciary APO examination for both Hindi and English medium students from 1st September 2025. You may enroll in those courses from our app and website. Whether it is for general North Indian belt judicial services exams, specifically for state specific exams like Uttarakhand, UP, Delhi, Haryana, these will be launched. See you in the next session. Thank you. God bless you.